Good afternoon, and welcome to this virtual lecture sponsored by the Nanovic Institute for European Studies at the University of Notre Dame. My name is Monica Caro, and I serve as Senior Associate Director of the Nanovic Institute. As you know, the Nanovic Institute is committed to connecting Europe and Notre Dame to Europe, as well as particularly supporting students, both graduate and undergraduate. In this next hour, we will be able to make this connection to Europe through reflections from Ms. Clare O'Hare. Ms. O'Hare is a graduate of Trinity College at the University of Dublin and received her LLM in commercial law from the University of Cambridge and a postgraduate diploma from Oxford Institute of Legal Practice. She gained admittance to practice law in England and Wales, as well as Ireland, and served in a variety of transactional work, advising governments and private clients on restructuring as well as other issues. She accomplished this work and has in-country experience in France, Germany, Ireland, and the UK, and even beyond Europe to Bahrain, India, Iran, Kuwait, and the UAE. But we are most fortunate that following this extensive experience, Ms. O'Hare chose to leave practice and return to the academy. Following an MA in law and diplomacy at Tufts, Ms. O'Hare started her graduate work at the University of Notre Dame, receiving her MA in the Department of Political Science, and is currently a JSD candidate at the Notre Dame Law School. She is currently engaged in the Nanovic Institute's Fellows Program, where, as you might suspect, she brings a rich perspective to an already dynamic group. Today, it is my privilege to host this webinar with Ms. Clare O'Hare. She will share her thoughts on the Irish judges at the center of the English Commercial Court. Ms. O'Hare will speak for about 30 to 35 minutes, and please feel encouraged to submit questions using the Q&A button at the bottom of your screen, because we will have time for questions following that. Clare, I yield the floor to you. Thank you so much.
Thank you very much, Monica, and thank you to the Nanovic Institute for all your support over the last 2.5 years. Nanovic has funded some of my larger research that looks at competition between countries to provide legal services. And good morning, good afternoon, good evening, wherever you happen to be. I hope if it's the evening, it's not too late where you are. So as Monica mentioned in today's talk, I'm going to introduce or really reintroduce two judges who were Irish, who were instrumental in setting up the English Commercial Court in 1895. The first is Lord Russell of Cologne, and the second is Mr. Justice Matthew. While they were Irish to their core, they were English judges, much like I was an English lawyer. Before we get there, though, I just want to say a few words about why the English Commercial Court is important, and in the context of competition between countries to provide legal services in the international business and financial world. So I have some slides, which I will share now, actually. Sorry, Nanovic, could I be able to share my slides? Until then, I'll keep going and sort of give you the overview without the slides. So London and New York are really the two big centers for commercial legal services, and the UK is second only to New York or to the US, and it's by far the largest legal market in Europe. And I'll just share some statistics here. Hopefully you can all see this. So in 2020, the revenue for the top 50 city law firms in London was over 10.6 billion. Now, English law is also said to be the most frequently used governing law in the world for cross-border transactions. And the UK actually exported about 7 billion worth of legal services in 2019 and only imported 1 billion. In 2010, some work was done that calculated that for every £1 spent on legal services, there was an additional £2.39 spent across the the UK economy. So really just from an economic perspective, you'd have to say, like, who wouldn't want a share of the pie? But it definitely goes beyond financial. So in 1995, Andrew Tang, who's now sits a judge in Singapore's Supreme Court, he spoke about the need for Singapore to move away from viewing itself as having a carbon copy of English law. And in fact, he said at Singapore at that point, he was afraid that they actually had a poor carbon copy of English law. and that Singapore should really look to developing its own commercial law and develop away from English law, obviously recognizing that history and that shared history, much like Ireland has a shared common law history with England, but developing its own path. And why? One, for the financial reasons I've mentioned, two, to attract businesses and develop Singapore as an international financial center. And thirdly, was to actually attract experienced, talented individuals into Singapore, and also to stop them leaving Singapore, because realistically, if English law is this law that people are using, and also attracts people to go and work in London and takes them out from, for example, Singapore or Ireland, if you want to look at that, or France. And Singapore was followed more recently with this, with Dubai, where I worked for a number of years, Qatar, Kazakhstan, Abu Dhabi. China has itself established two commercial courts, really to deal with disputes that arise out of the Belt and Road Initiative. And certainly there is this question within Europe that if more people are using English law and more frequently using English law, what does it mean for the development of law in those countries? And it has a feedback loop. The more English law is chosen, the more it becomes the preferred choice, the more people also gravitate towards it. And lawyers begin also looking to London. And for example, in 2019, a Dutch commentator said that this flight to London, and there was research done that showed that there were fewer and fewer transactions being governed by Dutch law. And this flight to London would ultimately have an impact on the Dutch court and the Dutch judiciary, because they were getting fewer of the very interesting cases that judges would like to work on. And he suggested that something had to be done to stem this tide. And with Brexit, there is this sense that perhaps there's an opportunity to compete with England and have this Brexit dividend for legal services with the UK out of the EU. So first of all, the Netherlands, I mentioned, they have a new commercial court. France has also set up a multilingual international commercial chamber, which it intends to staff with judges who they say will be competent in English common law as well as French law. And the importance of the courts, or even the English commercial court in this, is it's a way to also just to showcase what the law in a country can do. But it also, to some degree, the English commercial court represents this idea of the English legal system and English law being that sort of backstop law for commercial transactions globally. But what's really interesting is that when you look at the history of the commercial court, it emerged at a time when work was actually fleeing the courts towards arbitration. And you see a lot of the same comments that you hear within European countries about this flight of work from their countries. But in that moment, it was a flight from the courts and a concern that the courts would lose their relevance. And actually, the idea that London would be this preeminent centre for commercial dispute resolution, or the court would at least, would have seemed absolutely laughable in the 17th and 18th century. The English bench and bar at that time was described as particularly uncommercial. No one wanted to be anywhere near it. And while there was a bit of respite when Lord Mansfield was on the bench from 1756 to 1788, he couldn't live forever. And when he left the bench, the old habits came back. And really ironically for today, given the sort of, certainly from a continental European approach, the attempts to open up the courts to more of the English language and also to become more competent in common law. In that period, a lot of the claims from merchants were to have chambers, commercial tribunals, that looked much more like the commercial tribunals that were on the continent. But actually the biggest challenge to reform in the 19th century was Lord Coleridge, who was the Lord Chief Justice. And this is just a sort of a general kind of statement that you see in the press, not just the legal press, but the general press, that Coleridge was actually to blame for this flight of business from the court. And he was extremely, he vehemently opposed the idea that his judges should specialize. So much so that even when it came to commercial matters, so cases that were held in the City of London that would have been commercial, he would actually send judges who had never practiced in commercial law to hear those cases. So the business community generally just tried to avoid the courts because they had no interest in having their matters heard by judges who had no experience of their business, of their way of working. And one of the judges who was very involved with this was Mr. Justice Matthew, who was pushing for reform. And in 1891, he and Mr. Justice Bowen wrote to Coleridge with their ideas on reform, not just for commercial cases, but reform of the judiciary in general. Coleridge did call accounts of judges, and one of the recommendations was change to the commercial law procedure. But as Coleridge voted against it, it wasn't going to go anywhere. Others at the same time were experimenting with changing the procedure just within their own court. So Justice Gorrell Barnes, who sat in the probate, admiralty and divorce division, and you might be wondering why I'm talking about probate and divorce and commercial matters. This was a division that had sort of been put together, and the admiralty matters went into it. And with London as its sort of the maritime centre, there was a lot of commercial or quasi-commercial cases that could fall under that admiralty division. And he encouraged people to take their cases to his court with more flexible procedures. And he was incredibly popular. His court was very, very busy. But in 1894, Coleridge died, and at that point, Lord Russell of Cologne, whom we will get to know a bit better, he was appointed Lord Chief Justice, and he and Matthews again pushed for reform, and for various reasons, and for time reasons I won't go into, they weren't actually able to formalise any of the changes, so they innovated. They took a different route. So even though there were no formal rules that they could use to set up the court, they launched a commercial court effectively with this notice. And you can see this notice is very short. It effectively just said that commercial matters would be heard before a specific judge. That judge would make the orders that he felt were necessary for the speedy determination in accordance with the existing rules that were necessary for the matter to go ahead. And it was launched on the 1st of March, was the first day that it sat. And Matthew was seen as by far and away the best candidate for this court. You know, for several years, the legal press had been calling for this, and they had, as I've brought up here, they'd actually named Matthew as the judge they would like to have it. And in fact, he was named alongside Lord Chief Justice Lord Russell and Mr. Justice Collins. And the legal press at that point said that if that selection did not please the commercial world, nothing would. So Matthew was a great innovator. He really pushed for the judges to have more control of the cases to get them going. And he really forced parties to focus in on the matters at hand. But he didn't stand on ceremony. And I just like this little example here. And it's an example of that lack of fear of being a bit more informal. So it was a particularly hot day, and he decided to take off his judge's wig, and he asked the members of the bar who were there and told them that they could also take off their wig, and it got reported in the legal times of the day. So the innovations, as I said, were really how he ran the court, and it was described as he was rather arbitrary and practically forcing the parties to admit certain facts or documents which they might have been otherwise unwilling to do, but that there was method to the madness. And it worked, because a few months after the court was launched, in the legal press again, there was a report that the court's supposed competitor, the London Chamber of Commerce, that whatever vitality it possessed, it was derived from the temporary stupor into which the regular courts had fallen. But Sir James Matthew and his colleagues had changed all that. So he was really seen as the heart and soul of the commercial courts. But I think it'd be going a bit far to say that they were the only ones involved. Now, they were also protected, or the establishment of this court was protected by the Court of Appeal. Because I said it wasn't a court, there was just this notice that had established this way of doing matters, but everyone called it a court. So invariably there were people who challenged the idea that their matter would be heard by this new commercial court. And in one of the early challenges, the Court of Appeal said, no, it's not a court. Yet they still called it a court. It said there was no act of Parliament supporting it. And it was anything that was done under the regular rules, and that really the parties were agreeing to have these different procedures in place. So in a way, by not recognizing it as a court, which it legally wasn't, it had no act of Parliament, but treating it as one. The Court of Appeal really protected it from challenges to its legitimacy. And that obviously meant that it could continue and it could grow. And it did in the early years. It was incredibly successful. Now, it's not to say that the English Commercial Court has always been this success. It has always been busy. In the 1950s, Lord Devon, or he was Mr. Justice Devon at the time, he actually suggested that the court should be closed because there were so few cases coming before it. I think when I was doing this research, at one point there were 4 or 5 cases before the commercial court, and it was seen as given this gold-plated special procedures for commercial matters. And Devon's point was, well, if no one's using it, why are we putting our resources into it? But it's now today, it's thriving, and it's almost a heuristic for English law and the role of English law in international commercial transactions around the world. But the main part of this talk today is really to introduce you to Mr. Justice Matthew and Lord Russell of Cologne. So who were these 2 men, and what do we know about them, and why do we not really know about them today? So Russell was from Newry and Matthew was from Cork. And for those of you who don't know Ireland, Newry is there on the top right of my screen. I hope it's the top right of your screen with the larger arrow. And Cork is down at the bottom. So you can see these 2 judges, these 2 men are from very different parts of the country. They had a lot of things in common. They were both born in the 1830s. They also both had the name Charles in their name, although I'm not really sure that's really a character trait or anything. They both studied law at Trinity. Matthew did a degree. Russell actually only spent 2 years at Trinity, and he did that in order to be able to go to London and join the bar. Matthew was actually admitted to the Irish bar, but he never practiced in Ireland. He also went straight to London, whereas Russell initially practiced as a solicitor in Northern Ireland before joining the bar. And Russell was from Newry. Now, anyone out there who knows Newry probably also knows that the name O'Hare is frequently seen around Newry. So I do have a Newry connection. And when I saw the name Lord Russell of Cologne, when I was doing my research, it rang a bell. So I did what every sensible person does these days. I Googled it and discovered it's very close to Newry. It's about, I think, 20 kilometers or 10 miles or so from Newry. So I turned to my resident expert on all things Newry, my father, and asked him if he knew about the Russells of Cologne. And he did. Well, he knew the estate. He didn't actually really know much about the family as lawyers. In fact, 3 of them, Lord Russell, our Lord Russell, was his son and his grandson, all sat in the House of Lords. But he actually knew the estate well because he used to collect the posts from the estate, from the Gate Lodge, and he told me that the box was red, not green. So if anyone thinks that everyone in Ireland knows everyone else, I've probably just fed into that stereotype. But an insight into Russell's character really comes from a comment he made in an after-dinner speech. And again, anyone who knows people from Newry will probably smile at this. He said that the people from Newry think a great deal of themselves with more or less justification. And, you know, from everything I have read and the research, Russell also thought a great deal of himself, and clearly with some justification, as we will see. While he always wanted to join the bar, his family actually encouraged him to practice as a solicitor. So they thought it would be a safer bet than joining the bar, and he did. He practiced as a solicitor in Belfast, but he did a fair bit of advocacy, and he was often in the courts. And in fact, there was a judge that he was before, Judge Theophilus Jones, who's described in Russell's biography as a Protestant of sound Orange principles. He was very impressed with Russell's appearance within his court. And he was one of the 2 people, the other person was the Dean of Moore, who was also a Protestant, who encouraged Russell to join the bar. But Theophilus Jones encouraged him to go to England because he said, as a Roman Catholic, he'd have a very hard time in Northern Ireland. And Jones suggested that he go to Liverpool, where the Irish were very strong. I think that's really interesting because, again, it just shows this idea of London as a place to go to for opportunities and as a centre. You know, obviously there was a legal practice and there was a very, very active bar in Ireland, but that Russell would have had hurdles to overcome. And when we see later the trajectory of his life, he clearly made the right choice. And so he joined Lincoln's Inn in London in 1856 and practiced in Liverpool initially doing largely commercial practice, but he always lived in London, and like his biography shows that he's very clear, like he went to London. He did practice in Liverpool, but London was his centre. He was also a journalist. He wrote for the letter from London for the Dublin Morning News. He wrote for the Weekly Register, the Dublin Review. He later wrote for the Times and the Daily Telegraph, and his relationship with the Times sort of ends in the late 1880s when he represents Parnell in a trial. But in terms of like his success, he was very, very successful. So by 1881, so at that point he's been in London 25 years, his income was estimated to be about £14,500, which when I went onto a website that calculates what it is in today's money, that comes in at about £1.8 million sterling. And after Russell died, Mr. Justice Matthew wrote biographical notes, and he estimated that Russell had earned over £300,000 during the course of his career, which is actually over £37 million in today's money. So he was very successful. He was actually told at one point he could probably earn another £500 a year if he gave up his Irish accent. And he's reported that said he wouldn't do that even for the £500, but having seen how successful he was, I don't think he needed the £500. He was, I think you can imagine, like, given that financial success, he was a great advocate, and he seems to have had a great sense of theatre as well. He was retained for big society cases when he was in London, and if he was working on a divorce case for a woman, he always insisted that she wear black. And his ability to argue the law, I mean, some people perhaps rather unkindly said he didn't know the law, but no man could argue a law point better. And in terms of how he spoke to witnesses, it was said that he produced the effect on a witness that a cobra produces on a rabbit. But his chief fault was said to be his intolerance of stupidity, prolixity, or inaccuracy. And he really does not seem to have suffered fools gladly. But he also seems to have taken almost everyone as a fool. And it's reported that if a client gave a silly answer, he'd say, "You're a fool." Now, I don't know, I would love to have, well, actually, I wouldn't have tried that, but I'd love to have seen the reaction when I was practicing if I had said that to a client, or perhaps more so, I would love to have seen the reaction of the partners I worked with if I had ever said that to a client. I don't think it would have gone down very well. Another example that I think sort of speaks to Russell is one day he was on a train traveling back to London, and a man got onto the train, took off his boots and put on his slippers, and Russell was horrified at this man taking off his boots. So he threw them out the window. He threw the boots out the window, and he later felt a bit bad about this and apologized. And the man said, "Well, you can't do anything about it apart from apologize." And they chatted the whole way back to London as if nothing had happened. But, you know, he's not a single, he doesn't just have this harsh side to him. There's reports of, he loved poker and horse racing. And one of his daughters tells the story of how when they were children, he would play poker with them and their governess when they were very, very young, he and a family friend, and her father and the family friend generally won and would take the children's money, which the children didn't really appreciate. I don't think I would have either. But the next morning they would usually wake up and find the money back in their room. So in the end of the day, they didn't really mind losing to their father because they knew it would come back. So in addition to his legal success, he was very involved in politics. He ran as a candidate in elections several times. He was elected as an MP in Dundalk, and then later was an MP for Hackney in the Liberal Party. And Gladstone actually appointed him as Attorney General twice. And he was the first Catholic Attorney General for England since the Reformation. Interesting enough, at this point, he was still able to do his own work on the side. So he was very, very busy. And in terms of Irish politics, he was said to have known almost nothing about the political history of any country, including Ireland, but he was very happy and eager to learn. And he became very, very involved with the land question. And in 1880, he went off to Kerry, and he wrote a series of letters to the Daily Telegraph, which were then published in a book. with the title New Views on Ireland or Irish Land Grievances Remedies. Now, Russell says he didn't choose that name, that was the name given by the editors. And in it, he wrote that he was no apologist for the land leaguers, but at the most, they are but formulating and giving articulate expression of the feelings of Black discontent, which lie deep in the breast of Irish peasants. So even though later on, when he became very much part of the establishment, you know, as Attorney General, as Lord Chief Justice, he would make comments about the Irish question. And he told a story at a dinner party about an American who had lost an election and blamed the Irish in America for not voting for him, and then announced that he was going to go on holidays in Ireland. And when asked why would he go on holidays in Ireland when he clearly had a dislike for the Irish, the man said, because it's the only country in the world where English is spoken, where the Irish don't rule. And, you know, it's interesting to think of this coming at that point from the man who was the Lord Chief Justice. And again, like, while he was never part of Parnell's party, his views on the Irish question clearly brought him into Parnell's sphere. And in 1889, he defended Parnell in what we would probably call a fake news story today. So in 1887, the Times, who Russell had a general retainer with, published articles about Parnellism and crime, and included a letter that was supposedly signed by Parnell condoning the murder of 2 British government officials in Ireland a few years later. Now, Parnell denied he'd written the letter, he denied everything about it, and eventually a commission was set up with 3 judges to investigate various points, including the question of the letter. And at this point, Russell gave up his retainer with the Times, and his defense of Parnell was like it was a coup, and it was a piece of theatre. People came to watch it. Apparently, he demolished the chief witness. In fact, he was said to have smashed the chief witness, the forger of the letter, and proved that the letter had been forged. But in his closing speech, he went on to represent what he said was the misgovernment of Ireland, and said that he was speaking not merely as an advocate, i.e., he wasn't just defending Parnell, but he was speaking for the land of his birth, but also speaking for and in the best interest of England, because what was good for Ireland would hasten the true union and real conciliation between the 2 people. And Russell, he was a believer in empire, and he felt that empire gave a lot of opportunities to Ireland. The speech itself was published. Russell actually published, I've taken away the picture. He published it in a book form, and Lord Chief Justice Coleridge, who Russell then replaced on his death, complimented Russell on this and said it's not often that a man, by raising his own reputation to the highest point, can also do great and good work for his country. When in 1892, then he was appointed Attorney General, he represented England in the Bering Sea arbitration against the United States. And that was only the 2nd arbitration between nation states, and he won. Gladstone actually wanted to appoint him as the Lord Chancellor, but at this point, Catholics were still excluded from that post. So instead, he appointed him to the House of Lords, where he served for a very short time because Coleridge died in 1894. And at that point, Gladstone appointed him to the Lord Chief Justice position of England. And he was a political appointee both to the House of Lords and this position. And even at that point, he was still very, very busy. He participated in another arbitration, this time on the land border between British Guiana and Venezuela. He took a trip to Paris to watch the court-martial of Dreyfus because Queen Victoria wanted a report. Although when he wrote the report, he wrote the paper to Queen Victoria, he said he wasn't sure what was required of him, but he gave an overview of the proceeding. And he worked right up until his death. He was actually on circuit in Wales, and there's many letters he wrote back to his family. When he came back to London, he'd been feeling a little bit unwell and was on what he said was a milk diet. And there was talk of an operation, but he died, fairly suddenly. And it was seen as a great loss to the English legal system, to the bar, to the bench, and his funeral was a huge funeral. And there was, in fact, there was also a statue of him produced in the US because it was very highly thought of in terms of the arbitration work he had done. And he was cut off very much so at an early stage. And I think there's many reasons why we don't know so much about him today, and we will come back to those. But I think some of it was like his short tenure as well on the court. But turning now to the man who is seen as the life and soul of the court, James Charles Matthew. And again, this is a picture that's in the National Portrait Gallery of London, which is one of my favourite places in London. And I have to say, I don't recall ever seeing this portrait or the portrait of Russell, and certainly didn't realise they were both Irish if I did see them. So he had a brilliant career as a student in Trinity. He was admitted to the Irish Bar, as I mentioned, in 1850, but he never practiced, and he went off to London. And his two main interests throughout his career seem to really have been civil procedure and commercial law. And he initially practiced with a man called Thomas Chitty. Now, I don't know if there are any lawyers listening to this, but it's not it's not the Chitty who wrote the Law of Contracts. It's his brother, so still from the same family. But Thomas Chitty was a specialist pleader, because at the time the rules for pleadings were very, very technical. So you actually had to go to specialists who would write these pleadings. So Chitty never had to give legal advice, but he could write these pleadings. So that was one way in which Matthew first started to engage with these questions of procedure. And then he worked with a man called James Shaw Wiles, who was also from Cork, also a very successful commercial barrister, and who was later appointed to the bench. And Wiles had worked on the Civil Procedure Act of 1850. So again, there's these connections with civil procedure and how do you actually take a case to court and what would be an effective way to run a court. And when he took a few years to get established, and he was never as famous or as much in the public eye as Russell, except for on one occasion, which had an Irish question to it. He was very, very well respected in the legal world and successful in a professional capacity. Between 1865 and 1880, he appeared in more than 100 reported cases. Now, not every case is reported, so to be in 100 reported cases is pretty impressive. But he was also Lloyd's of London's junior counsel, which effectively meant that any commercial matter in the city came through him, given the importance of Lloyd's and the importance of the city for British trade. And there's stories of him rushing between courts. Similar stories are there of Russell, because they were both highly sought after lawyers. But unlike Russell, he wasn't sought after because he was an amazing speaker. He was known for his technical ability, his ability to really hone in on the important points. And that was what he brought to matters. He could identify that really the commercial points at hand, and it's why the merchants really appreciated him, because he understood them and he spoke their language. And when he was appointed to the bench in 1881, he's actually only the third Catholic appointed since the fall of the Stuarts. He, at this point, gets really engaged with trying to make change, this mission, I would say, to change civil procedure, which would take about 14 years before he had much success. But for Matthew, there was certainly more than just wanting to make matters run smoothly. Much like I mentioned earlier about the sort of professional pride, and that what happens when you lose cases, when you lose work to another jurisdiction. For Matthew, he was a commercial lawyer, but he was appointed to the bench, and there weren't many commercial cases because it was so slow to go through the court. So he was sent off to hear a lot of criminal cases. So he really did have an incentive to try and improve the situation for and the environment for commercial cases to come back into the courts, because that was where his expertise was. But when he started off, given he knew very, very little about criminal matters, his reputation took a bit of a nosedive, because he initially approached the criminal trials with the same brisk approach that he took to commercial matters. And like Russell, he had a fairly sharp tongue. So he was sort of castigated in the press by that. But he turned it around, and he eventually became very well regarded both as a civil and a criminal judge. And he apparently even managed to avoid outright rudeness over time, which doesn't say much about where he started from. But again, he still wasn't getting the types of cases that he really wanted. And this little quote here, I think, is a great example of that. It's 1890. He's been on the bench for, 9-10 years. And it says like he was a great commercial lawyer, But if he was relieved from trying to breach of promises and similar actions, which aren't, particularly big cases for him, and left only to deal with commercial causes, they doubted whether he'd find his time fully occupied. So again, it just shows like he wasn't getting the matters that he wanted. And I think this is part of the reason why he ended up in the public attention, because in 1892, he was asked to sit on the Evicted Tenants Commission, looking at the evicted tenants in Ireland. And whilst initially this was lauded in the press, it was a bit of a poison challenge or chalice. And he was appointed because some would say like he was a judge, he was an English judge, but he was known to be friendly with the leading nationalists, but he'd never taken part in politics. So I think in that sense, the government was hoping that they would appease everyone, that he could maybe bridge the divide. But not long after this sort of celebratory tone, things went downhill because he was criticized for many things. First of all, he was criticized for reading his opening remarks from a piece of paper, which proved that he had made up his mind before he came into the court. And secondly, he wouldn't allow direct cross-examination of witnesses at the commission. And big point came up when it was really a showdown with Edward Carson, the MP and QC and committed unionist, who was representing the landlords. He would not allow Carson to cross-examine the tenant witnesses. He said any questions had to go through the commission itself, and Carson stormed out. Matthew apparently always thought that the landlords hadn't really intended to participate fully in the commission, but Matthew became a focus of criticism, both in the press and in the House of Commons and the House of Lords. And at this point, what's interesting is Russell was the Attorney General, and there's very little out there about the relationship between the two men, but like we know they clearly knew each other. Matthew, as I said, wrote a biographical piece about Russell after Russell's death, including talking about like his financial success. And Russell stood up to defend Matthew, and he said that he wanted to say one word about Mr. Justice Matthew, and he hoped that the House would excuse him if he spoke with a little warmth on the subject, because Mr. Justice Matthew was an old personal friend. And he went on to defend Matthew and his integrity. But I really can't help but wondering if the commercial court had been up and running, whether or not he even had accepted the appointment, because when he does get appointed to the commercial court, he's incredibly busy. There's no lack of work for him. And at that point, he really is back in the good books. But at the end of the first year of the commercial court, so 1895 to 1896, there was talk that he would be replaced, and the plan had always been that he would sit on, that the judge appointed to the commercial list would be there for a year so he could see cases through, but that it wasn't going to be a permanent position. But when this came out, the merchant community was up in arms, and they sent a letter to Russell, who, as I said, was at that point was the Lord Chief Justice. And they said that the prospect perhaps no longer of Matthews being the dedicated judge, that they expressed a hope that no change would be made which would remove from the court the judge who had hitherto presided over it. So there was obviously a great concern that Matthew, after 1 year, would no longer be the presiding judge and the experiment would fail. I think we could probably ask about whether or not it's a good idea to have one person so associated with a court, but he stayed on, and he stayed on until 1901, when he was rather belatedly appointed to the Court of Appeal. I mean, generally the legal field felt it was very late recognition of what he had done. But interesting enough, at this point, the Times did call out that he was a Catholic who fled. Understanding of what people should be learning about. He also was very supportive of further studies in what he called, what at the time were Hindu and Muslim law. And I think perhaps also because of his time on the criminal circuit, he was very interested in criminal law reform, and he was part of the Humanitarian League, their criminal committee, and he once rebuked magistrates when he was on circuit, saying that who refused bail, saying that the price for the accused of these small offences, that it was highly unfair to leave them languishing in jail for months and months. But his memory seemed to have lived on a few years after joining the Court of Appeal, and died in 1908. And this piece that I have here is actually from the 1920s. And again, it sort of mentions about Lord Justice Matthew not really holding elaborate rules of practice in common. And that seems to really be his legacy, that he really pushed to have what he felt was excessive or stultifying procedures put aside, and that people should really focus on the matters to hand. So if we just want to think now about, like, so why aren't these two judges better known? As I said, like, my father, who's from Uri, very proud of being from Uri, knew very little about Lord Russell. And if they were so integral to the creation of this court that's being described as England's most successful invisible export, like, why do we not know anything about them? And I think there's two reasons for that. Certainly with Russell, he was better known as an advocate, and he did act on a lot of high profile cases. So he would have been less associated by the time he became well known with the commercial matters, although that was where his practice had started. When we think about his time on the bench, he was actually only on the bench for 5 years. And as I said, he was involved in an arbitration, and he had a lot of duties that meant he wasn't necessarily writing as much as there are hearing as many of the cases, but he was also as the commercial court, he was in a court of first instance. And for Matthew, it's a similar issue, is that, you know, he sat on the Court of Appeal for about 5 years before he fell ill. But when he was sitting in the commercial court, which he was so associated with, his decisions were very short. They were maybe 2 or 3 pages long. He didn't set out these great expositions of law and principles. He got to the point and he gave his decision. And he was actually very rarely appealed against. So the year before he was appointed to the Court of Appeal, he was only appealed against 16 times, and those appeals were only upheld 4 times. So there's 2 things there. Because his judgments were fairly short, there's not that much to kind of really grapple with. On the other hand, because he wasn't appealed very much, what he did write wasn't really looked at and then upheld and discussed. But I think it's a little bit unfair, the comment that has been made, that there's very little in Matthews for legal historians to look at, given his role in setting up this court that has become almost like the jewel in the crown, and it sort of represents English law and English law around for the rest of the world. The commercial court sort of represents English commercial law. But I think it's interesting also to think about where we are today, and sort of last week, actually, no, it was 2 weeks ago now, time is flying, another one of the big international law firms announced that he's setting up an office in Dublin. And I think it's really interesting to think about, you know, you had Russell and Matthew and many other people, myself included, who left Ireland and went to work in London, and, you know, in my case, in a big international law firm. And that we're seeing perhaps the reverse happening now. We're seeing Dublin become a centre that people might be looking at as the centre of international commerce. And it obviously it has been for a long time. It has very, very successful commercial law firms. But now seeing this, perhaps, you know, the tide going in another direction. I think, though, for Ireland, I think it's important to remember that Ireland is not the only country that has a lot of its nationals who've gone to work in London. When I worked in London, I had colleagues from all around the world. And as I mentioned, France has a lot of dual qualified French and English lawyers. And those lawyers obviously have an interest in seeing common law becoming more part of the French legal system. But I think it's an interesting, and it's curious for us to think about, you know, what would these 2 men have thought of, you know, their role in setting up this court that is so successful and so emblematic of English law. I wonder what they think of the discussions today, and what choices they might have made if they were here today thinking about opportunities that were there. But I hope that's been of some interest to you. If you have any questions, do please feel to reach out to me. I'm always happy to talk about these questions. And I think it's, for me at least, it's a very interesting point because it brings up so many different issues, just not just in terms of law, but the economy, about sort of how countries perceive themselves in the legal market, and also the never-ending question of Brexit. But thank you all for joining us, and please do get in touch if you have any questions. And I'm happy to take questions now.
And this is just a reminder to everyone you can place your questions in the Q&A button that you should see at the bottom of the screen. Claire, thank you so much for these wonderful portraits of these two individuals. I love the details that you found, whether it's from the red mailbox to the taking off the wig to the courtroom portraits. I think it's really gives us a fuller picture of these individuals and this important role that they played in this court. If I could just start perhaps by asking you a question of my own that relates to jurisdiction, and if this wasn't a typical court, did both parties have to consent to jurisdiction in the court, or how did they make sure that the clients agreed to hear their case, to have their case heard there?
So it was essentially you applied to have it transferred to the list, and if the judges felt, if at the early days, if Matthew felt it was appropriate, then he would consent to it. So in terms of the consenting, it was as much that once you were in Matthew's court, he didn't necessarily follow what we would call perhaps the normal rules of evidence. Like he would require that certain documents just be accepted as proof. So he sort of felt like with commercial documents, the parties should be able to agree that that is what is written on the paper should be admitted as evidence. So he sort of streamlined a lot of things, and that was the sense of that if the parties were in the court, then they were agreeing to run by his rules. And once the court was up and running, it was sort of taken that, well, you knew how the court worked. Therefore, by coming into the court or having your matter transferred to the court, you were automatically agreeing to this unwritten rules that became rules. And I don't think I mentioned it, but the court does become a court in the 1960s. It is given status under an act of parliament.
And I have one question that's come in here, so a bit of a historical one. Do you see the broader context of the battle over Irish home rule in the 1880s and 1890s inflecting Matthew's and Lord Russell's experience in helping to develop the English commercial court?
So I think that's a really great question, and honestly, it's something that I would probably, if I had time, to grapple with more. And I'll be very honest, I am not an expert in Irish history, being Irish. I think they were both very engaged with the question. They both, Russell actually initially didn't start off as a home ruler, but over time he becomes one. But they both have a sense of, from what I've read, a real sort of sense of unfairness and not wanting unfairness to happen. So I think in that sense, I don't think that probably affected their role in the commercial court in the way that with Matthew, like he was a commercial lawyer. He wasn't somebody who was out there defending people. He was representing the interests of the merchants. But in terms of who he was as a person, I think and certainly when he dealt with the criminal cases, I think you can see that a sense of unfairness is perhaps visible. But I wouldn't say that it feeds into their role in the commercial court. I do think that they both went to London for the opportunities. With Matthew, his family, his grandfather was Theobald, or not his grandfather, an uncle was Theobald Matthew, who was a fairly famous Irish priest. So he had access to that establishment. Russell as well, his family were there was an uncle, in fact, and his brother were part of the Catholic establishment in Ireland. So both of them had access to that capital to some degree. But I think their professional life in that sense as lawyers was separate. Obviously, Russell also becomes a politician and is very engaged with the Irish question as a politician.
Thank you so much. And one more that has come in. Your research certainly has a place in the scholarship on the influential role of Irish individuals in British imperial history. Do you see your work as making a contribution in this way? So how do you see your own work?
Thank you. So I'll be very honest, this is kind of fortuitous. And I think this is the bit that's so interesting is, like, I practice as a lawyer in London and Dubai with a big international law firm. And even when I was back in London pre-COVID, I met up with some people I'd worked with just to talk about the research who are lawyers in London. And this question about the commercial court. And no one that I spoke to mentioned that there were these two lawyers involved, which I think is like, clearly they didn't know it either. And when I started to do the research, when I first saw the names again, as I said, when I saw the name Cologne, I was like, oh, okay, like that rings a bell. But I wasn't aware of that connection. But I think it does have a space, and it is something I had hoped to work on it more. But as you and Nanovic know, I had a rather unpleasant accident last year, which has left me unable to see properly for about 7 months. So it was something I'd hoped to work into maybe an article. And I really do think it has a place in that question on empire as well. As I said, Russell believed in empire. He thought empire provided opportunities for Irish people. Now, he had friends who challenged him on that. But I also think it brings in the question for me as someone who's Irish, but I'm an English lawyer, and I went to Dubai and I worked in this common law center where I was part of that professional network that was promoting English law as a solution and English legal principles as a solution. It's something that's really interesting to grapple with. So I do think there's that overlap in thinking about the role of lawyers. And I know there's a lot of work being done about the role of Irish people in empire, not just empire and Ireland.
Thank you so much. I have one question that goes back to the Parnell case that you discussed briefly. People have called the Catholic Russell's defense of Parnell, a Protestant Irish nationalist politician, as a symbol of the lost opportunity to move towards a united, independent Ireland, achieved without bloodshed. Do you view that as that in that way as well, or how do you view that?
Again, this is definitely putting me outside of my comfort zone as someone who, like lawyers, I'll be like, oh no, I just want to talk about the law. But no, I think it is a really interesting point. And I think looking at even Russell's defense, like one of the things that he wanted to do was to bring out what he saw was the mismanagement. And actually, if the person who asked the question probably will know this, but the letters he wrote that were published by the Telegraph and these new views in Ireland, the introduction, like, is very, very interesting. He doesn't, it's not polite, let's just put it that way. At one point he says this might sound harsh to English ears, but like he wants to expose what he sees as the sort of inhumanity of certainly how a land is controlled in Ireland, the effects that it had on Ireland. I really did approach this looking more at like Russell and his role as an advocate and really this relationship with the commercial court. And it's a point that I think would be interesting, and I personally probably like to read more about, like, because Russell's views himself seems to have evolved over time. As I said, like, he's described as a man who knew nothing about any country's political history, including Ireland's, which is fascinating. And, you know, having an advocate like Russell, who was so well known, like, and seems to have also brought that question into the press of the day. But yeah, no, I think it's a really interesting question, and if I have time, you know, or maybe another life, I would definitely like to look at more.
And then perhaps as our final question to end on something closer to your legal expertise and a little more contemporary, this question is, how do you view Brexit? Do you view Brexit as an opportunity for a united Ireland, or what do you see as Brexit's impact in the Irish legal industry?
Gosh, Monica, I thought you were going to ask me an easy question there.
These aren't mine. I'm reading. I think it is an open question for the current situation and the Irish court's role post-Brexit.
So talking about the legal industry and the Irish courts role, I think the Irish government, or not, I think the Irish government has set up a new program called Ireland for Law, which is very much advertising Ireland, not just in terms of the courts, but like the whole legal structure that's an offer in Ireland. But they also aren't going kind of scattergun and saying, we'll take everything that's available in England. It's not possible to do work in England anymore. I mean, first of all, I think that no one would find that credible. What they have, the approach is very much to look at focused areas where Ireland does have that expertise and can compete. For example, in funds, maybe derivatives, aviation finance, maybe even life sciences, but also promoting Ireland as a country that is hospitable to dispute resolution, not just the courts, but also for arbitration. And recently, I think one of the things that Ireland can also do is showcase the fact that it has a fantastic judiciary. It also has a fantastic legal system. And most recently, there was a case looking at the COVID insurance matters. Now, there had been a case cited in the House of the Supreme Court, the UK Supreme Court, just before that. And the Irish court had then the opportunity to become the first court in the world to look at the English decision and kind of discuss it. And I think that's also a point that's worth noting, is that Ireland certainly has that opportunity to be able to comment, and perhaps, like Andrew Fang said 25, 30 years ago for Singapore, to look at ways at developing the law that is both competitive but compatible with the common law tradition that has become that bedrock of international commerce. On the United Ireland question, I might pass on that one. It's I think both the Keogh Naughton Institute for Irish Studies has had a lot of very interesting talks on this point, and I think it's, you know, it's a conversation that is happening, but it certainly goes beyond my expertise as a lawyer.
And there are plenty of more future conversations coming up, both at the Keogh Naughton Institute and here at Nanovic. So with this, it's my role now to thank Clare so much for her time and expertise that she's shared with us today. Please join us at the Nanovic Institute on April 13th, when our next virtual lecture will be with Italian Fulbright scholar Andrea Cartini, who's hosted here at the Nanovic Institute, as well as by the Center for Italian Studies. Professor Cartini will be presenting on nation building and national minorities, case studies from Europe. Until then, we send this with our very best wishes from the Nanovic Institute, particularly during this Holy Week.